Good day, everyone. My name is Dan Sampaio, and I'm delighted to welcome you to today's Mondac webinar in association with Gürkaynak Attorneys at Law, which will look at antitrust policy in digital markets and ask the question, are we headed in the right direction? We are joined today by a brilliant panel. Mr. Gürkaynak is a founding partner of Gürkaynak Attorneys at Law, a leading law firm of 90 lawyers based in Istanbul, Turkey. Mr. Gürkaynak heads the Competition Law and Regulatory Department of Gürkaynak Attorneys at Law, which currently consists of 45 lawyers. He has unparalleled experience in Turkish competition law counselling issues, with more than 24 years of competition law experience, starting with the establishment of the Turkish Competition Authority. Mr. Gürkaynak is joined by Mr. Miguel Perez Guerra, Head of Antitrust EMEA at PayPal. Before his current position, he had a leading in-house role at one of the leading technology and internet companies in the world, and he is particularly known to be vocal on matters relating to the interface between law and innovation. Now, before we get started, here is how you can get involved in today's event. You have the opportunity to submit questions to today's presenters by typing them into the questions pane of the control panel. You may send in your questions at any time during the presentation, and we'll address as many as possible during our Q&A session at the end of today's presentation. I would now like to hand you over to Mr. Gürkaynak to begin today's webinar. Thank you.
Thank you, Dan. This is much appreciated. It's truly very exciting to have Miguel with us today. As it is expressed in the introduction, Miguel has been intensively thinking about, writing about, and speaking about matters relating to the interface between innovation and law, technology law matters, competition law, interacting with the development of internet law and IT in general, and the role of regulation in the growth of technology-intensive markets. Could it be perverse? When would it be perverse? Could it be fostering it, and new concepts of competition law as well. So without further ado, I'd like to invite Miguel to have a conversation with me on the basic issues of competition law in the field of internet law and technology. I'd be curious to know if Miguel would like to comment on whether antitrust is insufficient as it is being portrayed in the more recent years. As the attendees might know, there is a significant camp now that is arguing that antitrust was very able to adapt itself and adjust to circumstances, and yet because of the very rapid development of things in the technology-intensive markets and the internet taking over particularly, now antitrust cannot change itself. It cannot mold itself quickly enough to serve the regulatory needs, and therefore a new quote-unquote toolbox is necessary, additional regulation is necessary. A lot of regulators are taking this view, some academicians are taking this view, some attorneys are also taking this view, and it seems it is now more and more being accepted as a fact, whereas obviously one has to take a step back and reflect on it as to whether there is truly a reason as to why antitrust would be able to integrate all of the changes in circumstances for more than 100 years, and then suddenly now antitrust is not functional anymore because there is a significant change in the landscape. What do you think about all these, Miguel?
Well, thanks. First of all, thanks, Dan, and thanks, Gönenç, for the kind words in the introduction. I have to start off by obviously giving out the standard caveats and disclaimers. I'm speaking on my own behalf. My views do not necessarily have to represent those of either my current employer or my previous, definitely not my previous employers either. It's the ultimate question, isn't it? Is antitrust enough? And we seem to be, as you rightly say, Gönenç, in a time when questioning whether antitrust rules that have served their purpose for sectors as far-ranging as railroads and oil, steel, all the way to telecommunications markets and everything that's in between, pharma, public works and construction, you name it. All of a sudden, because of a distinctive feature in tech, and not just tech, it's online markets, because let's not forget that telecoms is still, I would still consider it to be a highly technological space, as is pharma and biotech and biosecurity, but it's strictly confined to online markets where a sense or a notion of network effects and of potential tipping can take place fairly soon in the development of those markets / spaces. Some of them I would, like people to continue seriously considering whether narrowly defined markets are actual markets from a competition law perspective. But in any event, in this space, there is this general sentiment, societal, perhaps, political, definitely, that enforcement action is slow, it's inadequate, and the cases are not run as efficiently as they could, and that therefore other intervention tools are required. Ex ante regulation, for one. We have to remember that ex ante regulation traditionally has been used to tackle instances where there are structural inefficiencies in markets where there has been a traditional incumbent, usually a former state monopoly. If we think in terms of telecoms markets, utilities, energy, and so on. So the tide and the trend seems to have turned from situation with the Chicago school, laissez-faire, which doesn't mean don't do anything. It means observe the market, give it a chance to correct itself, to a more interventionist approach, neo-Grandesian, progressives, hipster antitrust, if you will, of not only considering that certain conducts are problematic, but that certain types of companies in themselves, their mere existence, can pose a threat to fair competition in these high-tech online markets. Now, it's the reversal of what traditionally, or traditional at least for the last 100 years, has been the mantra in terms of abusive dominance, right? All of us have grown up professionally with this idea in the back of our heads that big is not necessarily bad, that it's not dominance that's prohibited, it's the abuse of dominance that can pose serious issues to the competitive process, which is at the end of the day what antitrust law is there to protect. It's not there to protect individual rivals. It's not there to intervene when there is eviction or when there is an exploitation of a given particular competitor, but when the competitive process as a whole is threatened, when there is a restriction of competition, not of competitors. Now, the idea seems to be that indeed big is bad, not can be, is actually inherently bad, and that, echoing Louis Brandeis, whenever you've got a company in any given sector, but in particular here with online markets, size eventually leads to a higher degree of probability of a negative outcome for the market. I don't think, personally, I don't think there is enough evidence to unequivocally conclude that. I think that there have been instances, and there will continue to be instances, of companies of large size abusing their dominance online as offline. Antitrust and antitrust enforcement is alive and well. We cannot conclude that simply because a company has reached a certain size and has scaled up its services to attract consumers, that in itself is wrong. You can ask any business, any person who works in sales, any person who works in engineering, developing products. They will tell you that the ultimate goal is always to scale, to grow, but not by artificially excluding someone else. That is never the original goal. The goal is to do so by creating a product or service that is useful for consumers. When that product reaches critical mass, if you will, then obviously critics will pop up and say that actually the place in the market that the company A or company B currently has is not due to their products being better, and this is qualitative and it's subject to interpretation, it's very subjective, but actually that they've reached that position in the market because of their attempts at hampering competition, at tampering with the competitive process. And here comes the crux. These are very complex markets. Even though it may seem quite straightforward for Amazon to have become what it is today, I mean, yes, in hindsight, it was an excellent idea that Jeff Bezos had a couple decades ago when he decided to quit his job and open up an online bookstore that's turned into one of the biggest online, stress on online, retailers around the world. But then again, there was no guarantee that that bet was going to pay off. There was risk involved, business risk. And therefore to say that, you know, simply because Amazon is big or simply because any other company, Facebook, the GAFAMs, right? Google, Apple, Microsoft, Netflix even, that simply because they have had a product or service proposition that has attracted consumers, because these are good products at the end of the day, they serve a purpose, that in itself requires regulatory intervention without a specific conduct that can be proven to have foreclosed the market. And here's where we reaching the point of what's currently being hotly debated in the context of the Intel case in Europe, regarding proving that capability or likelihood that a given conduct by a dominant company will have an impact on the market.
Yeah, also it's interesting obviously to observe that if regulatory intervention were to happen without an abuse of conduct, on sheer size, then would the Bezos of today take the business risk and take that step, which brings us to the counterfactual analysis discussion. So are the regulatory authorities sufficiently engaging in the analysis of whether the intervention of today that is particularly designed to combat size and to label big as bad could be stifling the hunger, the need, the want for taking the business risks for the future. Also, you've used a few terms when you're explaining your thoughts, like tipping. One I can add is gatekeepers, for example. These are all vocabulary that has been introduced into competition law very recently, which shows that antitrust law is very much alive. Antitrust law is adapting itself and is molding itself, so much so that when we speak, we say with ease, tipping. And everyone who has been around in the antitrust circles understand it. Yet this term was nowhere to be found only 7-8 years ago. The same with gatekeepers, and now the concept of a gatekeeper is being used as a concept that is as widely accepted as having a dominant position. It's different than that, but it's as prominently featured in antitrust thought. So all of these are showing that antitrust is very much alive and kicking. And then, of course, you start wondering, so why would we then need additional ex-ante regulation, especially when there are no structural inefficiencies that can be demonstrated? It's also concerning, I'd say, from a historical perspective, when you look at competition not as a snapshot of a marketplace right at that minute, but as a process, which is what competition lawyers do. You had Nokia, you had IBM. At some given points in time, these companies looked like they're invincible. And with today's regulations and ideas, there would have been interference against these companies. One of them would have definitely been Nokia, would have definitely been found to have more than a dominant position. It would have been found as being super dominant in handheld devices, in what we call smartphones today. And yet now we know that that interference would have been awful, because it would have been an interference that is taking the place of a market correction that was going to happen the minute Nokia was going to feel complacent. And I'm not claiming that other companies are always going to feel complacent as well, but TikTok was nowhere to be found a couple of years ago. Now you're looking at a phenomena of TikTok, and Samsung is making life difficult for Apple, and it's a fierce competition going on in there. Apple was almost going under, and then on the merits of its new innovations, Apple has made it back into the scene in a very grand fashion, at some point they could have, with iPhone, they could have been found as having a super dominance-like structure as well. And there was no particular interference in there when Samsung took steps into that realm. So I guess what I'm trying to say is, if we don't allow the competitive processes to do their trick, it is going to be quite risky, because it will require a lot of micromanagement and a lot of assumption that regulators know best as to which direction markets are going to take and how things are going to happen. Which brings us to the discussion about counterfactual analysis, and also the need to recognize the existence of ecosystems which can be spoiled very easily if there is too much interference. Would you like to speak a little bit about these matters as well?
Yeah, yes. I think the key point here is perspective, right? And we may be lacking as a community, as an antitrust community, the perspective, the historical perspective and the contextual perspective of conducts and of specific companies regarding what kind of regulation is necessary. And note that I say what kind. I think we've all already moved past the point politically where we could fantasize or perhaps contemplate the possibility of no regulation whatsoever, aside from a proper and vigorous enforcement of existing antitrust rules. And yes, the conversation has shifted, but the question is still pertinent. Are we doing things with enough perspective? Because as you rightly say, I mean, even the staunchest critics of big tech companies are conceding that, because these critics, obviously, just like I do, they've got their own employers or their own clients, right? But those companies that have come out in storm criticizing other big tech companies, you start to hear rumblings that lead me, at least, to believe that they've also realized that a Digital Markets Act, Digital Services Act, will eventually also apply to them.
Yep.
And all these new regulatory tools, all these new regulations and new pieces of legislation that are being drafted both sides of the pond, so in Europe, but also in the US and around the globe, they've come to realize, well, hold on, yes, we can set the threshold for application of what a gatekeeper is and what a gatekeeper, there's different terms in different countries, but generally that's the term of art. Yes, you can set the threshold pretty high when it comes to defining what is and what isn't a gatekeeper, and you can narrow down the types of products that are considered to be core platform services. That's the terminology under the European DMA proposal. But at some point, these companies, these startups, some of which are no longer in the startup phase, that are, like I say, staunch critics and very vocal complainants of big tech, they will at some point, if they do things right, and most of them are, from a business point of view, nothing to object, they will become gatekeepers and they will be providing core platform services. And at that point, not just certain conducts, their mere existence will be scrutinized and their size will be scrutinized, regardless of specific conduct that could potentially be geared towards eliminating competition in their respective markets. So yes, I think that when I hear some of the representatives, external representatives, outside counsel of certain companies in certain sectors, I can't help but slyly smile, because you hear them saying, oh yes, it's good, but it's gone too far now. The DMA, as currently being negotiated between the European Parliament, the European Commission, and the European Council, hang on, that draft that came out of Parliament, it was good when it came out of the Commission, but now that Parliament has had its say, I'm not liking it that much. That's what some are saying. Careful what you wish for seems to be the immediate conclusion. And yes, it seems like certain companies are starting to realize, well, hold on, it's okay when it applies to Google, to Apple, to Facebook, but when it applies to me, I'm not so happy with this anymore. I'd rather have the traditional framework of analysis of, listen, it's not just size that matters, it's specific conduct, and that conduct needs to be proven to have at least the ability to exclude or to exploit rivals within the market. If it's not proven, and this is what Intel and the whole discussion around to what degree and by object abuses do you need to prove effects, at least potential effects, to be in the face of an Article 102 violation to begin with. So let's park efficiencies, justifications for the time being. We're trying to determine if a given conduct falls within the literal definition of Article 102 conduct. Well, to what degree do you need to look at effects, even if you're in front of what has been traditionally deemed to be a by-object abuse? And it seems that the Court of Justice has been clear about this for at least 5 years in abuse cases, for a bit longer if you look at Article 101 cases, so vertical restraints and so on. And now the General Court has finally last week said, well, yes, the standard here seems to be that you have to look at all the relevant economic circumstances at the time of the alleged infringement, look at that, and do a proper analysis of whether that had the potential to foreclose competition in the market. If we cannot conclude that, then the general principles of law, such as presumption of innocence, kick in, and they should kick in. I mean, one of the typical criticisms in the online space of antitrust enforcement is that it's too slow, that it's ridiculous, that it takes a case 10 years to be decided, and then an extra 5 years for the courts to weigh in, and then there's appeals that need to be, I mean, the whole Intel case has been running for over 10 years. When you consider that it was 2009, I believe, when the commission decision came out, and it's 2022, and the general court has now ruled the second time round after the Court of Justice said, actually, you got it wrong. Look at this again with these parameters. So the generally accepted criticism is it's too slow. But as I was saying earlier, these are very complex cases with very complex pieces of evidence, where things are not always as straightforward as they would look at first sight. And, you know, no one seems to bat an eye when they realize that criminal cases, when you consider the full length of investigation first, prosecution, judgment, appeal, second instance hearings, second instance ruling, potentially a third instance of appeal. When you consider the full journey that a criminal case typically goes through, you're in the same ballpark of a decade or thereabouts of investigation and rulings and appeals. This is to say, we can't lose perspective and lose sight of the fact that antitrust rules typically are quasi-criminal in nature. In some jurisdictions, they're literally criminal. You can have criminal penalties. People can go to jail for antitrust violations. So why are we okay dispensing with the protections that legal systems, Western legal systems, afford to individuals and companies that are defending themselves against criminal accusations in the context of competition law violations? I don't see a compelling societal or even political argument to say, well, listen, let's do away with all of this. Let's just create a new set of rules, a new corpus, legislative corpus, that will dispense with the notion of having to prove that there is dominance, of having to prove that there is at least the potential and the likelihood, the capability and the likelihood of negative effects arising from a given conduct. And let's just say that above a certain size, you have an extra set of obligations, because it leads to situations like the ones that I've described, where the companies currently, not even in 2022, in 2021, that would hypothetically benefit from those regulations because they would not be on the receiving end of obligations under the DMA or the DSA, have the ambition, the ulterior ambition, to become big. They want to become big because with size comes not just power, come profits. Scale and size are important in these markets, not just because companies want to be able to trash the competition and to crush everyone else. No, these companies have shareholders, at the very least the founders, right? And companies that succeed tend to have scaled in a way that allows them to profit from all the risk and that they've taken, from all the investment and the resources that have been poured into the company to bring to market products and services that are innovative. So if we decide, listen, as a society, we believe that the risk is just too high, big has to have an inherent component of badness, where do you draw the line to ensure that the aspirations of investors, of engineers who have created an innovative product, that those aspirations can still be fulfilled, at least, again, as I say, as a long-term aspiration? Because the minute you start factoring in, oh, there's a limit to how much you can grow, well, that's where you start seeing people just turning their backs on these sorts of investments. You wouldn't have, I mean, it seems to me slightly contradictory that countries, governments, I should say, governments in continental Europe are at the same time promoting the idea of championing national unicorns, so startups that reach the $1 billion or euro mark in seed investment, and at the same time are putting a hamper on the growth of online tech companies. It seems it would seem at least slightly contradictory to do that.
Yeah. On that structural point, also, and with our last 10 minutes to go, I'd like to invite you to comment on the more structural side of things as well. So we've been discussing the behavioral side, the conduct issues, the regulation of the conduct and all. But there's a whole different discussion and a different heading that one should have when looking into innovation matters in the M&A context. So merger control and the weight of innovation worries, the weight of innovation defenses as they should be featured in merger control. At the moment, I contend that there is a lot of lip service being paid to innovation. Everyone loves innovation. Innovation is so important. But unfortunately, also about sustainability, I believe that the case is the same. You're not seeing concrete policy preferences, changes according to these terms. So sustainability isn't making heavy inroads into the antitrust thought and reaction in view of certain matters. The same thing with innovation as well. It's sadder with innovation because it has been around for a longer period of time. And now everyone is speaking about innovation. No one disputes that innovation is such an important engine of economic growth. Everyone has come to terms with the idea that dynamic efficiency is so important among cost efficiency and distributive efficiency. Dynamic efficiency is basically the one with the highest potential of welfare maximization. Okay, these are all fine. But then you're looking at cases like Dow DuPont, Google, Fitbit, Illumina Grail, and you start and others, and you start realizing that whenever concerns are being articulated in the innovation sphere, then innovation is featured in competition law thought. But whenever innovative efficiencies are being used by defense counsel or by the parties as a defense, as a redeeming virtue of the transaction, suddenly they're dismissed as incalculable, too soft, what have you. When you look at Dow DuPont, my view is that you don't really touch concretely the anxiety that is featured there. That in and of itself had to be speculative as well, but there are leaps of faith that are possible because it's articulated as a worry by an antitrust watchdog. But whenever parties are flagging that there might be really important innovation gains here, those are just set aside very quickly. So the question then is, could you conceive that it might be academically and professionally interesting to argue that perhaps the burden of proof in the innovation matters in the merger control context should be played with in such a way that when the parties are flagging innovation gains, the authorities shouldn't be able to dismiss that it's not concrete enough, but they should perceive it as an invitation to look into it with their own resources as well. And there shouldn't be a very high standard of proof that the parties should be expected to pass to be able to put the burden on the antitrust agencies. Ultimately, the antitrust agencies are endowed with the duties to follow what is the goal of maximization of welfare, so some form of public welfare idea, which then means that even if the parties have a bad lawyer or an inadequate economist or a bad articulation of their situation in the innovation field, if the antitrust agency finds it plausible that there could be these gains, they should then take over and they should look into this. These kinds of things we're not seeing in the merger control field, and it just makes me feel that perhaps innovation is just a nice etiquette and an additional front of of worry for the antitrust agencies, but never truly a concept that is fully understood and embraced by antitrust in the merger control field. How would you feel about these?
It's interesting because the general sentiment seems to be running in the opposite direction, which is to say the burden of proof should lie squarely with the companies. And
yes.
and whenever I hear that, I tend to think, I mean, I may have been then involved in the handful of deals over the last couple of decades where the burden of proof was actually on the companies, on the merging parties to prove those efficiency gains. Or improvements to some form or degree, or synergies, whatever you want to call them. In my experience, it's always been on the merging parties to prove that those positive effects from a merger, especially ones where it's likely that some form of unilateral or otherwise effects might arise. It's incumbent on the merging parties to prove that the incentives simply are not there to engage in unilateral or in coordinated conduct rather, or that even if there are those incentives, that there's bigger incentives to behave properly. Let's not forget that merger control is not is not something that exists in isolation within competition law enforcement. You still have Articles 101 and 102 to discipline the behavior of companies post-merger. So yes, once again, personally, I think we as a community, as an antitrust community, are losing perspective of where the burden currently lies. To say that the novelty of the proposals are that the burden of proof will be placed on the companies is to ignore, to a degree, the fact that it already is incumbent upon the merging parties to prove what they are alleging are the positive side effects of a deal. It also puts a hamper to growth. Believe it or not, many companies, especially in the online space, are created and products are brought to market with the ultimate goal of being sold to a bigger company or of raising investment from specialist investment vehicles, from business angels, and so on and so forth. So part of the medium-term goal is, hey, if Yahoo comes along and buys my creation, I'll be a happy Larry Page. That was originally what was going to happen to Google, right? Google, in its initial form, Larry Page and Sergey Brin famously turned down an offer from Yahoo because they felt it was too low, after they had themselves pitched the idea of Google to Yahoo. So they sought out that opportunity. Imagine what the world would look like if that deal had come to fruition, right? It wouldn't be GAFM anymore. It would be YAFM or something like that. And, yes, of course, people want to be able to sell, but for that, you need to have a good product to begin with. And it's unlikely that you'll see these sort of deals where you're buying the company, the acquiring company is buying something that doesn't have a potential, but also it seldom happens, at least in the online or in the tech space. I don't know in others, but in the tech space, it seldom happens that you would buy something to literally kill it. So I think the tide of public opinion started to shift with Facebook, WhatsApp. And yet again, this notion of killer acquisitions, which was introduced back when Facebook, now Meta, had acquired Instagram and WhatsApp. This idea that companies of a certain size would simply buy out their rivals to prevent them from competing with the big established incumbents. I mean, to me, the real worry would be if someone were to buy an innovative product or an innovative company to simply shelve it. If the consumers, and here comes the the rationale for keeping the consumer welfare standard as the right test in antitrust cases, if consumers are still benefiting and receiving the full benefit of that innovation, then why would we as a society, as a political entity, decide, well, listen, I'm going to ban this deal because my crystal ball tells me that eventually, in 5-10 years time, if every single one of the milestones is reached, this company can grow and scale and become a credible rival to the company that is seeking to buy it.
Mm-hmm.
It's too far removed. Merger control, by definition, is forward-looking, but it has its limitations, inherent limitations. And the point is, where do you place the presumption? Are we pro-deal or are we anti-deal? And if we're anti-deal, what are the reasons for that? Because we cannot take such a big departure from what's been the traditional route in looking at merger deals without having robust evidence and a long list of cases. And I'm not talking about Facebook Giphy, I don't think that one counts, of deals in the tech sector where the sole purpose or the main purpose or the principal outcome was for the acquiring company to just put a hamper on the innovative smaller rival. At least in tech, I'm not sure about, like I say,
no,
I don't want to even speculate of other sectors, but at least in tech, I am not aware of instances where the big one has gobbled up the smaller fish and has literally swallowed it. Typically, it brings it in and it brings a level of financing and a level of resourcing and capabilities in terms of distribution, in terms of additional engineering resources and financing, I say, to make that product a success. And WhatsApp is an example, a good example, I believe, of the opposite of a killer acquisition. So is Instagram. I would mention YouTube and Android as well. Things that were in the very early stages of product development, and that the fact that they were acquired at the right time and for the right reasons meant that all of these became successes as they have. Yes, if we were applying that perspective, then you have to question, at least question, whether it's sensible to say that the burden of proof is not completely proper and properly allocated on the merging parties. Because I think it is. I think right now companies have to engage in quite a detailed level of analysis and prove not just that there are no negative effects, but to a degree that there's also positive effects and outcomes from the merger. So I think it's slightly off that to argue that there needs to be a higher burden on the companies to prove what they already have to prove.
Yeah, there are these mythological perceptions in the antitrust field sometimes by regulators. I find one is the sham compliance programs that are designed to liberate the upper management. I've been doing this for 24 years. I haven't been seeing companies doing this or trying to do this. Similarly, I think another thing is, I'm not saying killer acquisitions don't exist, but I don't think this is a predominant way of thinking and approach. When an incumbent significant company looks at TikTok of today, they don't intuitively say, oof, we should have bought them and killed them, because they know that if they had done that kind of a move, it was going to be MikTok, but it was going to be something else. It's just, it's very vibrant and very dynamic, and that's not how things work, basically. But regulators put a lot of emphasis on these things, understandably as well. But as you said, also there are so many good examples like WhatsApp, like YouTube itself, Android, and all. And some of those transactions would not have gone through today, which also should say something.
And the fact that companies or services such as TikTok have flourished, I mean, let's not forget that social networking is the paradigm of I mean, it's in the name of network effects at play, right? Yeah. The bigger you are, the more users on it, the more valuable it is. So it's a virtuous circle. And even there, you have a newcomer completely destabilizing the incumbent on a type of content, short videos, that the incumbent had not cared, maybe that's not the right word, but had not figured out how to commercially exploit, right? So there is always space for a newcomer, for an entrant, to basically unsettle or upset the existing balance, right? Having had the experience over the last decade of working on antitrust in the tech sector, I'm still surprised, and every year that goes by, I'm even more surprised at the contention that, you know, whoever gets there first mover advantage, wins, and it's competition for the market, not in the market. Because the market keeps evolving. We keep seeing new entry, some of it successful, some of it, many unsuccessful. Many of those cases are not successful. Truth has to be told. But there are very, very good examples of disruptors that are small startups and that completely upset the existing balance, and no one is untouchable. I mean, you mentioned Nokia. I would mention Yahoo. I would mention Alta Vista. You can mention all the social networking attempts that Google, with its might and its financial resources, attempted at building in order to overtake Facebook. Twitter is still there. There's plenty of other types of social networks. Snapchat, popular among teenagers. So there's plenty of space for growth and for disruption. So it seems like a foreign concept to me that things are set in stone and that no one is going to be able to displace. You want to say Facebook, Google, Apple, what have you. All it takes, and Apple knows it best because it's in its history, it's in its DNA, all it takes is a misstep. And I mean, people seem to have forgotten. That's why I keep coming back to this notion of perspective, that Apple was on the brink of bankruptcy at the end of the 90s, early 2000s, literally on the verge of bankruptcy. And all it took was for Steve Jobs to come back, for one, but for the company to launch a series of innovative products, starting with the iPod, and reinventing smartphones. The smartphones did exist before Apple introduced the iPhone, but they reinvented the whole concept of touchscreen, right? And it's that idea, it's that spark that will trigger success, and that has triggered success and continues to trigger success, not necessarily the fact that they're big. Big is not technically a parameter on which competition is measured.
Thank you, Miguel. This was wonderful, and no doubt it was passionate. I've been side by side you for very many years now on different cases and matters, and I knew that this was going to be a particularly lively session. Thank you for all this. So with that, we're concluding this terrific session. There is going to be a video recording of this that I will circulate as well. So for people who would like to send them to their counterparts whom they think might be interested in this, there's opportunity for that as well. Thanks again, Miguel. Thank you very much for your time and for your deeply insightful thoughts. Thank you.
My pleasure. Thank you very much for having me.